Be ready? Start. During the pendency of the suit, an application in terms of Order 39 Rules 1 and 2 of CPC was filed praying for an order of injunction and restraining the defendant from interfering with the possession of the plaintiff in the suit property and from taking forcible possession by breaking upon the padlock in the suit property stop. On such application, learned trial judge granted ad interim order of status quo stop. Against such order, the defendant filed an appeal before the High Court, which was heard by a division bench, and the said division bench did not interfere with the order as the main application for injunction was yet to be decided on merits stop. The plaintiff filed an application under Section 151 of CPC for enforcing the said ad interim order of status quo with the help of police, and the learned trial judge allowed the application stop. Thereafter, the defendant filed a revision before the High Court, but the High Court did not interfere with the said order on the ground that so long as the ad interim order was subsisting, there was no reason for interference with the order of implementation of the order stop. Subsequently, an application under Order 39 Rule 4 of CPC was filed by the defendant for vacating the earlier interim order stop. The High Court noted that it would have normally remitted the matter to learned trial judge for consideration of the application under Order 39 Rule 4 of CPC and the written objection filed to the original application for injunction on merits stop. But it was pointed out that in the suit the plaintiff had not impleaded the three sons of the defendant, who had admittedly become co-owners of the property along with the defendant, and as such no effective order of injunction can be passed in the suit in the absence of all the co-owners of the property stop. The High Court therefore held that in the circumstances it was a fit case where application for injunction filed by the plaintiff was to be dismissed in the absence of necessary parties to the suit, and on that ground alone the application was dismissed stop. The High Court noted that it had not gone into the merits of the case, and only on the technical ground as noted above the application for temporary injunction was rejected stop. In view of the dismissal of the appeal, the application had become infructuous stop. During hearing of the appeal, learned counsel for the appellants, who are the legal heirs of Ashok Kumar, the original plaintiff, submitted that the High Court had not decided the case on merits and had passed the impugned order only on the technical ground that the three sons of the defendant, who are co-owners, had not been impleaded stop. As a matter of fact, subsequently, an application in terms of Order 1 Rule 10 within bracket 2 read with Section 151 of CPC was filed by the plaintiff on 8/11/2005 for impleading the three sons of the defendant stop stranger. The prayer was accepted by the trial judge by order dated 19/4/2005 stop. As the basic objection as to the maintainability of the application no longer survives in view of the impleaded of the three sons of the defendant, the matters need to be heard afresh stop. As noted above, the High Court noted that it had not gone into the merits of the case, and except on the technical ground of non-impleaded of the three sons of the defendant, the application was temporary injunction was rejected stop. In view of the changed circumstances, we remit the matter to the trial court to consider the matter afresh stop. The effect of the impleaded of the three sons of the defendant, needless to say, shall be considered by the trial court stop. The appeals are accordingly disposed of. Stop. There will be no order as to costs. Stop. Stanza. On an examination of the pleadings of two writ petitions, we find that the issues for consideration were all different in the petitions. Stop. In the first petition, relief was sought under the Contract Labour Act 1974, abolition of contract labour system in the operation of canteen in the marketing establishment of IOC, and for absorbing the canteen workers as employees of IOC. Stop. In the second petition, relief was sought under the Industrial Disputes Act 1947 for making a reference under section 10 within bracket 1 to the Industrial Tribunal to decide whether the contract between IOC and the canteen contractor was sham, nominal, and a mere camouflage to avoid extension of labor law benefits to the workers in question, and whether the canteen workers were the direct employees of IOC. Stop. Stanza. The assumption that the appellant had taken inconsistent stands in the two writ petitions is not correct. Stop. Even in the first writ petition, the appellant had contended that though the contractors changed from time to time, the workers in the canteen remained the same with continuity of service, that IOC had malafide and illegality kept the workers as contract labor in order to keep them in a permanent state of insecurity and to deny them the wages and privileges available to permanent workers, that IOC was actually controlling and supervising the canteen, and that only as a camouflage the contractor was shown as running the canteen to create a pretense that the workmen of IOC were the workers of the contractor, when in fact they were the employees of IOC. Stop. In short, the appellant had contended that the contract was sham and nominal in the first petition. Stop. Even in the second writ petition, the contention was that the contract was sham and a camouflage to avoid extending benefits of regular employees to the canteen workers. Stop. Therefore, the High Court committed a serious error in assuming that in the first writ petition, the appellant had considered that the contract between the IOC and the canteen contractor was valid and genuine, and that in the second writ petition the appellant had taken a contrary stand, that the contract was sham and a camouflage. Stop. Stanza. The stand of the appellant and the workers was always consistent. Stop. But therefore the decision of a constitution bench of this court in Authority of India Limited versus National Union Waterfront Workers 2001 within bracket 7 SCC 1, it was thought that the appropriate relief available was to seek an investigation and abolition of contract labor and consequently seek absorption. Stop. Therefore the prayer was made in the first petition. Stop. This court held that even if there was an order under section 10 of the Act prohibiting contract labor in any process or operation, there would no automatic absorption of the contract labor by the principal employer. Stop. It was also held that it is always open to the contract labor to urge that the contract was sham and nominal by raising an industrial dispute, and such dispute will have to be decided by the industrial adjudicator and not by the High Court. Stop. Stanza. When it became clear after the Constitution Bench decision that if the case of the workman is that the contract between the principal employer and the contractor was sham and merely a camouflage to deny benefits of the workers, then they could raise a dispute and approach the industrial adjudicator, the appellant short reference stop over.